Good evening, Professor Webb.
Good evening, Professor Webb.
It's me, Ms. Hetzer.
And I, Chevannes.
And today we're going to be discussing the Board of Education of Westside Community Schools
versus Mergens.
Now let's take a look at the parties of this case.
And the parties of this case are the Board of Education of Westside Community Schools and Bridget C. and Daniel N. Mergens, displayed here. They are a father and daughter duo who fought against the Westside Community Schools.
Okay. Now let's take a look at the facts of the case and break down the background as well.
All right, so the issue regarding this case is whether the school's denial of official recognition to a proposed Christian club violated the Equal Access Act. The Equal Access Act prohibits federally funded public secondary schools which allow non-school sponsored groups of students to meet from discriminating against any meeting of students on the basis of religious content if, number one, the meeting is voluntary and student initiated, 2, there is no government sponsorship, and 3, no unlawful activity is permitted. The EAA applies to public secondary schools that receive federal funds and allow non-curricular student groups to meet during non-instructional time. The EAA prohibits schools from discriminating against meetings based on religious content as long as the meeting is voluntary, student-initiated, and does not involve unlawful activity. For example, a high school with a debate team must also allow students to start a club that discusses their religion or beliefs. The EAA protects students' freedom of speech and religion. Now let's get into a little bit of background about this case. Westside High School, a public secondary school that receives federal financial assistance, permits its students to join on a voluntary basis a number of recognized groups and clubs, all of which meet after school hours on school premises. Citing the Establishment Clause and a school board policy requiring clubs to have faculty sponsorship, petitioner school officials denied the request of respondent Mergens for permission to form a Christian club that would have the same privileges and meet on the same time, terms, and conditions as other Westside student groups, except that it would have no faculty sponsorship. After the board voted to uphold the denial, respondents' current and former Westside students brought suit seeking declaratory and injunctive relief. They alleged, inter alia, that the refusal to permit the proposed club to meet at Westside violated the Equal Access Act, which prohibits public secondary schools that receive federal assistance and that maintain a limited open forum from denying equal access to students who wish to meet within the forum on the basis of religious, political, philosophical, or other content of speech at such meetings.
Thank you. Now we're going to be discussing more about the case and how it moved to the Supreme Court. So as we discussed in Business Law 1, we talked about how the cases can move from the trial to the appeals and then to the Supreme Court. And within this case, it began when the school board upheld the administration's denial of the club. Thus, Mergens and several other students decided to sue in this matter. The case on appeal from the district court, the Court of Appeals was found to be in favor of the students, and under Westside, on a writ of certiorari, the case was moved to the Supreme Court. Now to understand a little bit more about the Equal Access Act, we're going to discuss that. So the Equal Access Act was created in 1984 and was passed by the Senate 88-11 and in the House of Representatives 337 to 77 and was motivated by Supreme Court rulings. So there are cases similar to Board of Education of Westside Community Schools versus Mergens that relate to the Equal Access Act that the act was essentially based upon. Those include Winmar versus Vincent, a 1981 case, Engel versus Vitale, a 1962 case, and Abington School District versus Schmepp in 1963. So the Equal Access Act of 1984 applies only to schools that allow students to form groups not specifically linked to their curriculum. This act only applies to groups that meet during non-instructional times under the same terms that non-curricular clubs function. And since then, the Equal Access Act has been amended. So let's talk a little bit more about other facts of the case.
So, Nebraska high school student Bridget Mergens had requested permission to form a Christian club at her school with all rights and privileges of access and under the same terms and conditions as other student groups on campus, with the exception that it will not have a faculty sponsor. The school denied Mergens' request, arguing to allow the formation of such a group would violate the First Amendment's Establishment Clause, which prohibits government from establishing or promoting religion.
Thank you. Now let's discuss the legal issues and religious freedom relating to this case. So when relating the case to religious freedom, we're going to discuss the Free Exercise Clause and the Establishment Clause. So the Establishment Clause is a section of the First Amendment of the United States Constitution that forbids Congress from making any law respecting the establishment of religion. Moreover, the Free Exercise Clause is a section of the First Amendment of the United States Constitution that protects citizens' rights to practice religion as they please, as we should. The ruling of 8-1 established that the Equal Access Act did not violate the First Amendment's Establishment Clause, which relates to this case, validating that since Westside Community Schools allows other non-curricular groups to meet on the premises, it is bound by the Equal Access Act to permit other groups to meet and cannot deny such permission based on religious content of such meetings. The Establishment Clause prohibits government from establishing an official religion or favoring of one religion over another, which is quite important, or over non-religion. It also prevents government from limiting the free expression of religion. Now, continuing to look at relating to religious freedom. So when looking at religious freedom, this case essentially takes on the argument that school officials should not be discriminating students based on their religious beliefs or lack thereof, in such that they cannot prohibit students from holding religious clubs on school grounds when other non-curricular clubs are permitted to do so, which we'll see the importance of that moving on.
Okay, and this quote is a quote from the case itself. It shall be unlawful for any public secondary school which receives federal financial assistance and which has limited open forum to deny equal access or a fair opportunity to or discriminate against any students who wish to conduct a meeting within that limited open forum on the basis of religious, political, philosophical, or other content of the speech at such meetings.
Thank you. And two key figures are Justice Sandra Day O'Connor and Justice Roberts. Justice Roberts was not in the mostly majority opinion of this, but Justice Sandra Day O'Connor's mostly majority opinion gave insight to the history of the case, including the role of the previously stated case that was the basis of the Equal Access Act, Winmar versus Vincent, the 1981 case, and the Equal Access Act, which clearly intended to apply to standards outlined in Winmar to public schools. Justice Sandra Day O'Connor's key sticking point, she acknowledged, was the term of the use non-curriculum related school group in the Act, as well as the inclusion of federally funded schools. O'Connor weighed several possible approaches to resolving this before arriving at the court's solution, and under such, this case followed a three-pronged test to which established the court's decision. Now let's move into the court's decision. Shamal, would you like to take that away on whether we agree or disagree?
The ruling upheld the constitutionality of the Equal Access Act. This ruled that public schools cannot deny religiously affiliated non-curricular clubs from meeting on school grounds. Delaney, do you agree that this case and that their ruling was constitutional?
I agree that the ruling of this case was agreeable due to the fact that it did not violate the U.S. Constitution based on the Equal Access Act of the First Amendment. What is your opinion on this?
I agree as well, but a small side note that I would like to add is that although the only difference for this club was that she requested no faculty sponsorship, which goes against their policies, however, not enough to deny the club altogether.
Yes.
And the courts agreed with this, saying that this ruling is agreeable due to the act of not violating the U.S. Constitution.
Thank you. I think it's also important to note that we have the right to establish religion as we please within ourselves, and we should not push that on anyone, as stated by the First Amendment and and relating to education and the Equal Access Act of the U.S. Constitution. Thank you.
Thank you, Dr. Webb, for your time.
We hope you feel better.